So bad news for the government. It's lost another constitutional case. Gonna break down the legalese for you and tell you why the court has said the government acted unconstitutionally in imposing states of emergency, multiple states of public emergency between 2018 and 2023. I'm Dion Jackson Miller. Thanks for joining me courtside. Time for tea. So big ruling from the Supreme Court in a case where the opposition had challenged how the government was going about imposing states of public emergency. And the court said, yes, there's a big problem here. And as a result, they said that 14 states of public emergency that had been declared between 2018 and 2023 had been unconstitutional. I think this was a good judgment. It was well written. It was well reasoned. It was easy to follow the reasoning of the court. I agree with all of the points they made in this judgment. And best of all, it was pretty concise as constitutional judgments go. 44 pages, so big up. So let's first talk about declaring a state of public emergency. That's because before you can understand the ruling, you have to understand how it is a state of public emergency is declared. Now, the government can declare a state of public emergency. That, though, is only going to last for 14 days. If the government wants a state of public emergency to go beyond 14 days, they have to go to Parliament and they have to get the support of the opposition. So the Andrew Holness administration had imposed a whole string of states of public emergency starting in 2018. First, the opposition had said, all right, crime high, we'll vote to extend. Then they started to express some unease. And then after that, they said, hold on, we don't think this is being used in the right way. And they stopped playing ball. So what that meant is that the government could impose a state of public emergency, but couldn't extend it. So then they came with a new strategy. What they would do is declare a state of public emergency. It would run for the 14 days, then it would expire. Government would wait a few days, and then it would announce another state of public emergency in the same area. We call those rolling SOEs because, one would kind of roll into the other after a short break. So look, from the started with this, everybody said problems. It was clear that what they were doing was to try to maintain the state of public emergency in place for an extended period of time without having to deal with the opposition. And it had unconstitutionality all over it, quite frankly. So the opposition said, not a blast here in court. So ta-da, here we have now the ruling of Dayton Campbell against the Attorney General of Jamaica. Dr. Dayton Campbell, of course, is the General Secretary of the People's National Party. So let's take a closer look. And let's start with whether the states of public emergency were being declared for the reason, the purpose set out in the Constitution. So the Constitution says you can't just get up whoops one day and declare a state of public emergency. There have to be certain circumstances. And that's why whenever he was making the proclamation to declare a state of public emergency, the Governor General would say that he had been advised that action had been taken or is immediately threatened by persons or bodies of persons of such a nature and on so extensive a scale as to be likely to endanger the public safety of the community, and that as a result, a state of public emergency existed in whatever community it was they were going to be saying the state of emergency had been declared in. Because that is one of the criteria that the Constitution says has to be in place for a state of public emergency to be declared. Others, for instance, hurricane, earthquake, war, and so on. Deputy Commissioner of Police Blake gave evidence to the court to try to say, yeah man, the circumstances were in place to warrant the imposition of states of public emergency. He said the increase in crime and the emergence of new types of criminal activities had led to an increase in the murder rate in most parishes. He said it had become increasingly difficult for the security forces to suppress or contain crime using existing legislation and/or normal policing methods, mainly because of a lack of human resources in the police force. Well, the court never buy that argument there. What the court said was that what was being described was an ongoing state of affairs that the police have had difficulty managing over an extended period. And the court said there's logic and good sense in the assertion that a state of affairs which persists over a period of years cannot properly be described as an emergency. And then them draw for the Oxford Dictionary to define what an emergency is. And what Oxford said is that an emergency is a serious, unexpected, and potentially dangerous situation requiring immediate action. But the court said the evidence from DCP Blake showed that the states of public emergency were being used as a method of policing over an extended, albeit not continuous, period of time. So they said they were not of the view that the states of public emergency declared by the Governor General between January 2018 to February 2023 had been declared for a purpose specified in the Constitution. Those states of emergency, therefore, said the court, were inconsistent with the Constitution and are void. So were the states of emergency demonstrably justified? So the Constitution gives us rights. The Constitution also says, though, those rights can be restricted in some cases. But if the government is going to restrict our rights, it has to show, using the words of the Constitution, that those restrictions are demonstrably justified in a free and democratic society. In other words, you can't just get up one day and say, "Boops, state of public emergency, restrict rights." The government has to meet what is called the Oakes test to show that the restrictions are demonstrably justified. So first of all, the objective of whatever it is the government is doing has to be important enough to justify restricting rights. Then, whatever is done has to be reasonable and demonstrably justified. It can't be arbitrary, unfair, or based on irrational circumstances. Also, the right in question has to be impaired as little as possible, and the action should be proportionate. In other words, can't take a sledgehammer to kill a mosquito. The issue here wasn't at all the government's aim. The court accepted that this was a legitimate aim. The court said it's beyond dispute that the ultimate aim of the government in imposing the states of public emergency is to curb the level of crime, which undoubtedly was and still is out of control. So that wasn't the issue. The issue is, how did the government go about doing that? Now, the government was arguing that the states of public emergency had been declared for the purpose of securing the essentials of life in the communities affected. But the court said, we don't see that. They said no such evidence had been presented. They said DCP Blake's affidavits do not purport to set out the action that satisfied the Governor General that each state of public emergency had arisen, nor did they identify the person or bodies of persons who had taken such action. They said instead what DCP Blake did was to describe in very general terms the high rate of crime in various areas. In addition, the court said, hold on, you gave us some stats, but the stats do not support what you did. And also, the stats show that the states of public emergency are doing what you claim they're doing. And I'm going to quote from the judgment a little bit, and that's because we've heard so much about how the states of public emergency curb crime, and the court said that's not what their analysis is showing. So they said the evidence of DCP Blake is that while there was a 50% reduction in crime for January 2023, there was actually a 22% increase in murders in February 2023 when a state of public emergency was in effect in St. Anne. They say also from December 28, 2022 to January 10, 2023, and then from February 15, 2023 to February 28, 2023, there were states of emergency in force in Kingston West. But they said DCP Blake's evidence is that from January 1, 2023 to February 10, 2023, West Kingston had the highest number of murders and shootings across all divisions. And he also said 17 persons were murdered and 12 reported shootings took place. But they said when you look at what happened compared to the same period the previous year, there had been a 31% increase in murders and a 20% increase in shootings. Then they looked at St. James. They said the evidence showed that since 2018, there had been 11 states of public emergency in St. James, including the extensions. But they said DCP Blake's evidence shows that as of November 8, 2023, St. James had the highest number of murders across all police divisions, with a total of 169 from January 1, 2023 to November 15, 2023, and the highest number of shootings. That is 101. The court said DCP Blake nevertheless claimed some success in reducing murders over a short period during the imposition of a subsequent state of public emergency. So the court said, contrary to DCP Blake's assertion that the impact of states of public emergency had the effect of reducing murder rates and shootings, the stats don't bear that out. They said this is a clear indication that the measures did not always achieve the objective of reducing crime. The court also made the point that while rights may be restricted to ensure public safety and maintain public order, the restrictions should be temporary so that the rights are impaired as least as is reasonably possible. They also made the important point that the constitutional rights of members of certain marginalized communities will be disproportionately affected as there is increased policing of such communities. They said there is likely to be an erosion of public trust in government and negative implications for social and economic stability. So the court said, the government can't just come and say they're doing something so important that they can just trespass on fundamental rights. They need receipts. They need tangible evidence. And the court said the very existence of guaranteed entrenched fundamental rights and freedoms which have special protection is a clear recognition of the fact that legislative, executive, judiciary, and individuals have been known to abuse their power. Prevent this, the rights and freedoms that are entrenched, that means they have special protection under the Constitution. Those rights and freedoms are to be given pride of place in all circumstances unless stringent conditions for overriding them are met. Also, the government went overboard with the states of public emergency. Remember, if you're going to restrict rights, you have to restrict them as little as possible, and you can't be arbitrary in restricting them. The court pointed to the evidence of DCP Blake that the main areas of concern in St. Anne were Stairtown, Mansfield Heights, Parrytown, Pineapple in Ocho Rios, and Miami Bay. All of those are in northeastern St. Anne, but the state of public emergency was imposed in the entire parish of St. Anne, and the court said this represented an unnecessary restriction on freedom of movement, right to protection from search, the right to freedom of peaceful assembly, the right to liberty, and the right to due process. All of those rights are adversely affected when you impose a state of public emergency. Then you had the issue of whether the declaration of the states of public emergency violated separation of powers. So the constitutional principle of separation of powers is a rule that essentially says what the different branches of government do and how they relate to each other. So the three branches of government, just as a reminder, you have the legislature or parliament that makes laws, you have the executive headed by cabinet that sets policy and does the day-to-day running of the government, and then you have the judiciary that interprets the law. So remember I said the government was imposing these rolling states of public emergency. They'd impose one, wait a little bit, impose another, so they wouldn't have to go back to parliament because the opposition wasn't supporting an extension. And the court basically said, no. When I try to go around the Constitution here, so the court said the present constitutional arrangements require the participation of the executive as well as the legislature, that's Parliament, to properly secure an extension of a state of public emergency. The court said the declaration of a new state of public emergency within days of the expiration of one, in circumstances where it could not be said that a new emergency arose, the court said that's a method of circumventing the constitutional provisions and process. Then there was an interesting question raised. Did Dayton Campbell have standing to bring the case? Now, it's an interesting point. I know people have been talking about it because we're all consumed with the fact that the states of emergency, the imposition had been declared unconstitutional. But this is really a nice, interesting point. The government had been saying that Dayton Campbell didn't have standing to bring the case. Standing meaning not sufficient interest in the matter. The government says he didn't live in an area that had been affected by a state of public emergency and his rights weren't directly affected. But the court battled at the argument and they made what I thought was a really nice and important point. They said you can go to court to protect the constitutional rights of your community. even if you yourself are not directly affected. They said, though the claimant, that's Dr. Campbell, may not necessarily be directly affected by the executive's use of the state of public emergency, the broader society is invariably affected. Therefore, it's reasonable to conclude that the claim is in the interest of the public. They said, when considering public interest litigation, the beneficiary is not just the person who is challenging the decision of government, it's the wider public who will benefit from the outcome. So they said, yes, Dr. Campbell had standing to take this case to court because this was a public interest case and the issues affected the wider society. The reason I said this is a great point is that when constitutional cases are brought against the government, almost invariably, the government tries to attack the person standing and saying they don't have sufficient interest in the matter. So I love the fact that the court has taken this position. All right, so the government says they're going to appeal, so we'll see what happens when it reaches further up the line. All right, I have to leave it there. Thanks so much for joining me courtside. Remember to like the video, share with somebody who might be interested, subscribe to the channel if you haven't yet done so, and click that notification bell so you know anytime I drop a new video. I'm Dion. Thanks again for watching. Back to my tea.